So we're starting into chapter 3 now, and if you've got your books, go ahead and open them to chapter 3. There's a couple of things here that I want to go over that I think are important. We're going to look at about 3 different things real quickly in this chapter. First of all, I want to look at what the goals of sentencing are. Then I want to look at some of the sentencing structures that we have, and then finally I'm going to wind up talking about some of the issues of sentencing that cause some of these sentencing structures to change over time. So let's look at what we consider to be the goals of sentencing. Now, your book lists about 7 of these. I condense them down into 5, and so do a lot of other authors. So that's what you're going to hear me talk about are 5 of these. The first one that I want to mention is what we call retribution. Now, your book lists revenge and just desserts. Most authors put just desserts and revenge into the category of retribution. So when I talk about retribution, what I mean is this is a form of punishment to where we are punishing the individuals because they're getting what they deserve. There's no rehabilitation here. There's no really protection of society. We are punishing these individuals as a retaliation, is they're getting what they deserve. An eye for an eye and a tooth for a tooth. That's what retribution comes down to. The second one that I want to mention is what we call deterrence. Deterrence means that we're punishing here to deter someone from committing the crime again. Now, if the deterrence is for a specific person, in other words, if it's aimed to make sure that that one individual does not recidivate, then that is called specific deterrence. If we're implementing punishments to deter the general population, that is what we call general deterrence. But deterrence looks at how do we discourage or prevent crimes through the fear of punishment. Deterrence assumes that individuals will consider the punishment before they commit the crime, which I think is wrong. Most individuals that I've dealt with in law enforcement do not judge or weigh out the punishment before they commit the crime. The third one I want to talk about is incapacitation. Incapacitation is here to do one thing. What it does is it protects society. Basically what we're doing is we're taking the individual, we're putting them in the prison not for a punishment purpose, but the purpose is to protect society so that person can't get out and commit any more crimes. The next one that I want to mention is what we call rehabilitation, or you may also see this as reformation or reintegration. Punishment for rehabilitation purposes means that what we're trying to do is we're trying to reform the individual so that they can go back out and be a productive member of society. We are, as the term says, actually rehabilitating them. The final one that I want to mention is what we call restoration. Restoration is a new term that we have, and it's, when I say new, within the past 5 to 10 years. And what this does is this attempts to return all of the participants in the crime, that being the victim, the suspect, and everyone else involved, back to a time beforehand. We want to make these individuals whole. Restoration simply looks at how can we involve the community, how can we involve family members to come and make the victim and the suspect whole again, and we're restoring the community. So that's in a nutshell what these actually are. Now I want to look at the different sentencing guidelines that we have and types of sentences that we have here. These are the models. There's 2 models that I want to talk about. First is what we call indeterminate sentencing. The second one is what we call determinate sentencing, and I am going to throw a third one in there, and that's just the sentencing guidelines. Indeterminate sentencing. North Carolina for years operated under an indeterminate sentencing model. Think of indeterminate sentencing as the judge has a wide range. If you ever see court television where you see somebody get punished to 25 years to life, that is an indeterminate sentencing model. What that means is this individual is going to do anywhere basically from 25 years up to life in prison. They can do less than 25. Indeterminate sentencing is based on rehabilitation. Whenever somebody is rehabilitated as determined by a parole board, they can be released. This also allows for good time, as long as they're doing what they should in prison, as long as they're taking classes to reform themselves, then they can work their sentences down. Indeterminate sentencing was popular back in the 50s, 60s, and 70s, and even North Carolina had it. Well, then we switched to a determinate sentencing, and the difference is this. Indeterminate, judges have wide discretion. In determinate sentencing, judges have no discretion. In other words, if we say that a person is going to do 25 years, then they're going to do 25 years. There's no good time. There's no gain time. North Carolina has a form of determinate sentencing called structured sentencing, which we're going to look at in this module. Judges have to give a specific sentence that is mandated by the legislature and virtually cannot be reduced for any reason. So why do we have this? Well, what we started having happen was questions about proportionality, equality, and social debt. Proportionality looks at, does the punishment fit the crime? And in the 80s and 90s, and somewhat in the 70s, we started having a lot of, or what we thought was a lot of, juveniles and people committing very serious crimes, and we thought that they were getting off lightly. So some states started seeing that judges they didn't think were having enough harsh sentences imposed on these criminals. Equity deals with, are we fairly sentencing people? In other words, if we have two different defendants that are committing the same crime, are they going to be punished the same or as close to the same as possible? Equity allows us to also consider social debt. In other words, if a person has a criminal history, then technically they have a higher social debt, and therefore their punishment for the current offense should be a lot higher. Determinate sentencing, structured sentencing in North Carolina, takes all three of those into account. It looks at, does the crime and the punishment fit? Are we punishing people equally because the legislature sets the punishment standards? They set the guidelines. They set the what we can count as far as a person's social debt. They consider that. And then finally, the legislature says that if a person has a past criminal history, then we can use that against them. So that's what we're going to be looking at in Chapter 3. If you have any questions, please post them on the Q&A forum or feel free to email me.